Good morning and welcome to the first of 3 presentations we're going to be sending out to you over the next few weeks regarding the Renters' Rights Bill and what will be changing on the 1st of May 2026. We've got 67 days now until the New World Order where lettings is concerned. It's the biggest changes to lettings law in the last 40 years. And so what we've decided to do, we're going to break this down into 3 different sections to make it a bit more digestible, give you a chance to really think about what we've said and come back with any questions. And this is the first of the 3, as I say, that we're going to cover. So we're going to start today with what's going to change when you create a tenancy. So the process before a tenant moves into a property. Presentation number 2 will be about managing a tenancy. So what happens once your tenant's moved in and what you are and aren't allowed to do. And then part 3 will be about ending a tenancy. So if you want to bring your tenancy to an end, what the process will look like. So we're starting today with, as I say, creating a tenancy. And we're going to cover today marketing your property. So what are the new rules regarding advertising, how you accept offers, selecting a tenant, what you might want to look for moving forward, the referencing process, anything that may have changed there. And then lastly, before your tenant moves in, how you take their payments and create an AST. So under the Renters' Rights, from the 1st of May, there's going to be new anti-discrimination protections, which go way above and beyond the current existing Equality Act of 2010. So there's already discrimination laws in place. For example, you're not allowed to put no DSS on adverts. All of that comes under the Equality Act. You're not allowed to discriminate in terms of gender, age, etc. However, moving forward from the 1st of May, you will no longer be able to discriminate either against families, people who might claim benefits, and any tenants with pets, although exceptions do apply to that, and I'll come on to those shortly. This could also include as well asking specific tenants for guarantors when you don't ask any other tenant for guarantor. Now, this is just at the point of advertising. So once referencing is back, you are entitled to then say to that tenant, look, I'm afraid you're going to need a guarantor because of your referencing. However, at the point of advertising and booking a viewing and selecting a tenant to move forward, you won't be able to ask one tenant for a guarantor and not ask another for a guarantor. You'll have to take a blanket approach to it, okay? So landlords and agents, if you're managing any properties yourself, you must not make someone less likely to rent a property because they have children or they're in receipt of benefits, okay? This includes any stage of the letting, so whether that's withholding information, stopping someone from viewing, or stopping them from signing a tenancy agreement. Now, again, there are some caveats to this. So if a tenant has misrepresented themselves either at the point of booking a viewing or at the viewing, and then once they've passed referencing, you find out their situation is not what they've said, then obviously you can go back and say, well, look, you didn't tell me that at the start, so circumstances have changed. So for example, if they said, no, I've got 1 child, it turns out they've got 5, or they've got no pets, it turns out they've got 4 dogs, then absolutely the tenant has misrepresented the situation, and therefore you can ask them to provide further information, further protection. However, you must treat everybody the same at the point you are marketing your property. That's the general rule now. At no point can you discriminate against any person at the point you are marketing, booking viewings, and then looking to proceed with an application. Now, the interesting thing about this is that blanket bans and discriminatory clauses have been abolished across the board. So one of the common questions we get when we're putting forward a tenant who might claim some universal credit, for example, is our landlords will often say, my mortgage company won't allow that, my insurance company won't allow that. Well, as of the 1st of May 2026, mortgage companies and insurance companies are also banned from discriminating against people on benefits or families, etc. And so if those clauses are in your mortgage or they are in your insurance policy, they will be null and void as of the 1st of May 2026. So what are you allowed to do? Well, you're absolutely allowed to make a decision based on affordability. If you feel someone can't afford your property, then absolutely you can say, look, this property is not for you. I don't think you should view it. You can also make decisions on overcrowding. So best example here, you have a 3-bed house and you have 3 sharers who come along and say, we want to rent this house with 3 friends. Depending on what council you're in, that might create an accidental HMO. So Salford Council, for example, where we do a lot of work, 3 adults that are unrelated becomes a HMO, even if it's just a standard 3-bedroom house. So you can absolutely at that point say, no, look, we don't want sharers. I'm looking for a family tenant because putting sharers in creates more legalities for me as a landlord, more cost, and I don't want to go down that route. So you are absolutely allowed to do that still. You are allowed to refuse pets in the event that the property is unsuitable. Now, you have to be really careful here, but in our opinion, the only way is really a property can be unsuitable is if it's an apartment, and therefore it's probably in the lease somewhere, the head lease, that you're not allowed to have pets in the building. Although quite often the lease will state it can't be a pet that roams free. So again, things like hamsters, guinea pigs, anything that might be in a cage, you might not be able to refuse. Or if, for example, it's a HMO and it's a shared house and there's other tenants in the property to consider, you're absolutely within your rights to say no, you can't have a pet. However, if you are renting a 3-bed semi-detached house with a garden and someone says, I've got one cat or one dog, the reality is you will not be able to refuse that. We've seen various comments about, well, what if the landlord's allergic? Our opinion is that's not going to stand up. If you went to a court, you're not living in a property as a landlord. Yes, you might say I need to access it for maintenance, inspections, etc. But in reality, the court would side in favour of the tenant if you were to use it as an excuse for not allowing a pet. You are absolutely still allowed to choose the best tenant for your property. There's nothing to stop you doing that. So all you have to do is apply the criteria fairly to every applicant. Now, if your property is being marketed correctly and it's the right price, then the idea is you should have more than one tenant who's looking to rent your property anyway, or we would certainly hope so. And in that case, you can absolutely still choose the best tenant for you. So if you feel someone without a pet is a better option for you, then you're absolutely allowed to make the decision that you go for a person who doesn't have a pet. Okay. All the law is requesting and stating is that you have to apply the criteria fairly to every applicant. Now, the other thing that's coming under the renters' rights is that you now must advertise a rental figure, and that is now mandatory. To be honest, we would never advertise a property without a rental figure. However, I have seen it in London where they have things like POA, for example, price on application, generally for the much higher end properties. But anything like that after the 1st of May will be illegal. You must state a specific rent on an advert, and you must state what that rent includes as well. So whether that includes any bills, or whether bills are excluded. You must not invite, encourage, or accept any offers over and above that advertised rent. So you cannot encourage bidding wars, and you must not accept a figure from a tenant that's over and above that advertised rent, even if the tenant volunteers it. We do have this occasionally where a property is particularly popular and tenants will say, oh, if I offer £50 more, would the landlord consider me? In the new world, after the 1st of May, you would not be able to take that extra £50. You cannot sign a tenancy which is at a higher figure than the advertised rent. This will apply to every assured tenancy after the 1st of May. It basically means you've just got to publish a rent and stick to it. That is going to be the top figure you will receive for that property, regardless of how much interest it gets. Now, if you're to break these rules, the penalties are being increased substantially. So these are civil penalties, fines, and they'll be dealt with by trading standards or the local council. And you can be fined up to £5,000 or £7,000 per offence, potentially more than that if you're found to be a repeat offender. Now, the other thing is with the new rules the councils have received from December, the point of negotiation has now moved away from the landlord or the letting agent. Effectively, the council will now contact you, give you 28 days to provide evidence, and then decide if you're in the wrong. There is no negotiation period now with the council. They will basically make a decision off their own back. So moving forward to how you select a tenant. So once you've done your advertising, you're happy with it, you made sure it's all legal and you've not broken any laws. We now do some viewings and we now put tenants forward to you to say, look, these people are interested in your property, and now these are things that you need to be looking for. So the key difference between 28th of April and the 1st of May is, as you probably already know, tenancies will have no fixed term. So tenancies will not be tied in to any form of contract after the 1st of May. They'll effectively be able to leave just giving 2 months notice. Okay. Now, what that means is there is a danger that certain properties might get used as effectively Airbnb. I would like to stress, we do think this is highly unlikely at Infinite, because the process someone has to go through to take out an assured tenancy compared to the process of getting an Airbnb is far more rigorous. If you go for an Airbnb, there's no credit checks, etc., no referencing, there's no right to rent checks. You're literally just putting some money down and you move straight in. Whereas tenants do have to jump through quite a few hoops in order to get into one of our properties and one of your properties, hopefully. So it is highly unlikely, but you do need to be aware that if you have a city centre furnished apartment, you are definitely going to be more at risk of a transient style tenant who will move in and after 2 months decides actually this is not the right building for me, or works too far away, I don't have any friends in this area, and I'm going to move on. Basically what we're suggesting is, obviously, when you're assessing your tenants and who you want to move into your property, what we need to establish between Infinite and yourselves, or yourself if you're managing your own property, is that tenant's reason for wanting that property. Okay, what are their ties to that area? Where do they work? Do they have children in local schools? Do they have family in the area? If you've got a one-bed city centre apartment that's on a furnished basis and you've got a potential tenant who's moving from London, just started a new job in Manchester, doesn't really have any connection to the area, that is where you're going to be at risk of somebody moving in and thinking after 2 months, actually this is not the right property for me, I've made a bad decision, I'm going to move somewhere nearer to work, work's not moving out, I'm actually going to go back to London. Whereas if you've got you could have the same apartment, a tenant who's been in their job for 3 years, lives in a building round the corner, just wants something a bit more modern, already knows the area, has got friends in the area, drinks in the area, goes out to eat in the area, then the likelihood of that tenant moving after the first 2 months is pretty slim, I would suggest. So the previous items we look for in terms of credit history, affordability, all those things, while they're still vitally important, these more niche areas now are going to become key to deciding which tenant you move forward with, because in the new world the turnover of tenants could become a lot higher if we're not checking these things. You may well want to consider making guarantors mandatory moving forward, given the fact that tenants can move a lot quicker. Evicting tenants could be a lot more difficult. Then you might want to look at making guarantors mandatory. Again, if you're going to do that, we'll probably need to state that on the advert to say that, look, everybody needs a guarantor for this property. The one thing I would say is you do need to be aware that you could really limit your tenant pool by saying, no, everybody has to have a guarantor. We have some really good tenants at Infinite who don't have guarantors, young couples, both working, can't provide a guarantor for various reasons, might not have the right family member. And some people don't want to be guarantors. It is a big commitment. So if you decide to go down the route of saying, no, I absolutely want a guarantor for my property, then you may well limit your tenant pool. But as well as that, you need to make sure you're selecting the right guarantor. So who is it they're putting forward? Generally, at Infinite, we'll only accept family members. So mother, father, son, daughter, sister, brother. They tend to be our preferred guarantors. People do come to us with friends, bosses. It doesn't really work. You don't have that embarrassment factor. Friendships can end in 2 weeks. Relationship with bosses can end in 4 weeks. And they've got no hesitation about stitching that person up if it's not ended particularly amicably. So we want somebody where the idea is it's going to be a long-term relationship with that person, and they've got that embarrassment factor. They don't want us ringing their mum when they haven't paid the rent. They don't want people knowing their business. So if you are going to take a guarantor, you need to consider who that guarantor is, not just accept anybody. And most importantly, will your tenants and guarantors pass referencing if you're going to use rent protection? So they're only allowed a limited amount of adverse credit, normally less than £1,000 in CCJs. They have to meet affordability. They have to be able to pass ID checks, landlord referencing, etc. And I would consider that as a mandatory thing for just about every tenant, regardless of whether or not you're taking out rent protection. Use that as your base point, if you like, for the quality of tenant you're going to be dealing with moving forward. One of the things you need to be aware of, and we've seen this recently at Infinite, is fraud is massively on the rise. We've had at least 3 or 4 cases I can name recently where our referencing company have turned around to us and said, we can't move forward with this person, we can't tell you why, but we can't move forward with this person. If you are self-managing a property, you do your own referencing, etc., you need to be really aware that we are seeing more and more people with fraudulent pay slips, fraudulent bank statements, and because people are so desperate to get into a property and rents have increased so much, people are doing everything they can to try and meet that criteria and pass the referencing just to get into your house. Obviously, Infinite, we use the country's biggest referencing company, Good Lord. They tend to, rather than use things like landlords references, pay slips, they will use things like cross-referencing with HMRC. We use open banking, so every tenant links their bank account to our referencing so we can see their wages going in and their rent going out, which means it's a far less open to fraud. They can't just provide pay slips which might have been doctored, etc. And they have to link their bank account. It's not just providing bank statements, which could have been amended. So they have to physically link the bank statement to our referencing system so we can check that those payments are being made and coming in as per the other documentation they've provided. So compliance on landlords has also increased at the point of referencing. You may or may not be aware, some of these things aren't new, however some of the penalties are. So as a landlord and a letting agent, we have to make sure that everybody who moves into a property has the right to be in the UK. That's been the case since 2016, so that's not a new point. So we've been doing this for quite some time. So by checking that, what we mean is you have to provide, or the tenant has to provide a copy of their passport or their visa if they don't have a British passport and permanent right to reside. Now, this is not just at the point of moving in, so you don't just do this at the point of creating the tenancy. So for example, if you move somebody into your property with a 2-year visa, it's your responsibility as landlord stroke letting agent to check in 2 years' time that visa's been renewed. They're dealing with the Home Office to get an extended right to remain. If not, you have to then report them to the Home Office and ask them to leave your property. Okay, so this is not just at the point of signing a tenancy. This is to be checked throughout the lifetime. If your tenant at the point of signing has a UK passport or permanent right to reside, obviously you don't need to do any further checks. You can assume they're allowed to stay in the UK indefinitely. However, if they're moving in on a limited visa with a limited time span, you need to keep checking that visa during the tenancy period. Now, what has changed is since 2024, the fines for this has gone up to £20,000 per instance, not per landlord, it's per instance. So if you have 3 tenants, all of which fail their right to rent checks and you've still allowed them to move into the property, or you haven't checked their visa when it expires, you can be fined £20,000 per tenant. So that's £60,000 for 3 tenants potentially. Obviously, Infinite, we're doing this as standard through our Good Lord referencing system. The right to rent checks are carried out and then they're diarised automatically to be checked up again whenever the visa might expire. One thing that is relatively new though, from 14th of May 2025, all letting agents and landlords in the UK are required to carry out financial sanction checks on every adult tenant and guarantor. And as letting agents, we also have to carry them out on landlords. So this is to comply with the new anti-money laundering regulations. A sanction check is basically a check with the government to make sure that whoever you're dealing with has not been financially sanctioned or blacklisted, if you like, by them. So that might be because of their politically exposed person. It might be they've had some illegal history. It could be various different reasons. Landlords also now need to supply proof of ownership of the property to a letting agent, and we're going to be sending out an email to all landlords where we don't have this information over the next few weeks to explain what we need to do and how we need to bring the files up to date before the new rules kick in on the 1st of May. And just to be clear, if you're self-managing your property, you need to carry out these same checks on all of your tenants and guarantors. So you need to be carrying out financial sanction checks on them. Now, initially when this came in at May 2025, the rules were unclear and it made it look like it was only from that date forward these checks needed to be carried out on anyone we dealt with from that date. However, further legal advice has confirmed that all of these need to be backdated. So any tenants you have living in your properties that aren't managed by Infinite, if they moved in before the 14th of May 2025, you need to arrange to have them financially sanctioned checked because this information is supposed to be backdated. Now, it is just a one point in time check. So believe it or not, we take on a new landlord. We do a financial check, financial sanction check at the point of signing the terms of business. We don't have to do it again moving forward. It's a once in a lifetime check, and it is a check per landlord. So from a letting agent's point of view, if you have more than one property, we only do this check once, and it's the same whether you have one property or 15. Okay, so moving on now to how you take payments and create your AST or APT as it's going to be called after the 1st of May. So This is where things have changed slightly and made it slightly more complicated, and where landlords could quite easily come unstuck if you're not careful. So before all parties sign the AST, the maximum payment, or the only payment you can legally take, is a 1 week holding deposit. So at the point somebody says, yes, I want to proceed with an application, I want to move forward with this property, you are allowed to take a holding deposit equivalent to 1 week's rent, not a penny more, before you sign the AST, but that is the only payment you can take. Before you take any further money from a tenant, so whether it's a security deposit, the balance of rent, everybody must have signed the tenancy agreement. So landlord and tenant must have signed that tenancy agreement, must be executed before you take any further money. Now, the complication is it leaves a landlord in a very difficult position. So once that tenancy agreement is signed, as a landlord, you have to hand the keys over for that property. Whether or not the tenant pays that first month's rent, you are committed. If you don't hand those keys over, say the tenant doesn't pay, if you don't hand those keys over, effectively it's the same as going and changing the locks on a tenant, and you've broken the law. Okay, you've restricted access, you've broken the law. I'll come on to this in a second, exactly what this means, and the difficulties could create. You are absolutely allowed to still take 5 weeks security deposit, and you can still offer deposit insurance schemes such as Reposit. The key difference being you cannot take that security deposit until both parties have signed the tenancy agreement. So just to clarify this point I was saying about taking payment. So the way we work at the moment is the tenant, so we do the referencing, we send the landlord the referencing report and say, okay, we've got everything back for this tenant now. We're happy to move forward. Are you? Landlord says yes. We send the tenancy agreement to the tenant to sign. So the tenant signs at that point. Once a tenant signed, we would then ask them to pay their moving monies. So this is their security deposit and the balance of their first month's rent, less the 1 week holding deposit they've already paid. Once we've received that money, we will then sign the tenancy agreement on your behalf. Both parties are committed to that tenancy. The moving date is confirmed, but we've already got the money on account for that moving date. After the 1st of May, what's going to change is we get the referencing back, send it to the landlord, say, I'm happy to move forward. Landlord says yes. We send the tenancy agreement to the tenant to sign. It then comes back to us. We then sign the tenancy agreement on your behalf, or you would sign the tenancy agreement yourself. That tenancy is now executed. So both parties have signed. That is a legal contract. Both parties are bound to do what they've agreed to do. Okay. At that point, then the tenant will pay the moving monies, ready for moving in. But this is where the danger lies. And that tenant could not pay that moving money. You as a landlord are then committed to hand the keys over. The tenant is absolutely committed to pay the rent, but obviously you've got to follow the chasing process, the arrears process, and potentially the eviction process. If they don't pay that money, you can't just refuse to hand the keys over. Okay. Now, one key point I would say here is if you have our rent protection policy, none of this will cause a concern for you because you're protected from day one. There's no excess period on our rent protection policy. So if your tenant doesn't pay the very first payment, the Good Lord rent protection will kick in from day one. I can't say every other policy would do that. You need to check that with your provider if you use your own policy. But with our rent protection policy, if the tenant moves in, hasn't paid the rent, you will get paid from day one regardless, and we'll just follow the arrears and eviction process. You need to be very careful with how you word your agreements moving forward as well. So because the payment structure has changed, any old agreements you've been using, the wording won't be correct. If you decide to go to court on an old agreement and you haven't worded the payment structure correctly, you're going to leave yourself in a lot of trouble and potentially damage any eviction and have the judge rule in the tenant's favour. So the way the tenancy agreement is going to be worded moving forward is going to change dramatically with regards to payment structure. If you take the wrong payment at the wrong time, or if the wording is wrong in the contract, it will completely invalidate the tenancy agreement and leave you completely exposed as a landlord. So the other thing moving forward from the 1st of May is you will no longer be able to take rent up front. So the maximum period you can charge rent for is 1 month. You can do less than 1 month. You can do weekly, you can do fortnightly, but you will not be able to take any payment of more than 1 month up front at any point in time during the tenancy. It's not just when the tenant moves in, but even once they've moved in and during the future. There is no workaround for this. Again, I've been on landlords forums and seen things saying, oh, what if the money's held in a letting agent's client account, or the tenant offers it and we agree it's not rent, it's an extra deposit, etc. There is no legal workaround for this. If you take more than 1 month's rent, you'll be breaking the law. There is no workaround at all. Now, this could dramatically again impact the tenant profile you might be willing to accept. So in the past, we've dealt with students. In Warrington, we've had a big influx of people from Hong Kong who generally can't provide the checks that we would normally check, so affordability checks, proof of residency, etc., proof of address. And the way around that is they would normally offer 6 to 12 months rent up front. We would ask the landlord if they're happy with that. Most landlords would say, yeah, okay, we'll work on that and then deal with it again in 12 months' time. You won't be able to do that moving forward, okay? So even a student, even somebody moving from abroad who can't provide normal referencing won't be able to get around that by offering you more rent up front. They also won't be able to get around it by offering more rent than the advertised price. So if they decided to say, well, I'll pay you £200 more per month to gradually build up my rent account, because you've advertised a property at a certain point price, you can't accept more than that advertised figure. So coming on to what a tenancy agreement will look like moving forward. So an AST is now going to be null and void, and from the 1st of May, everything will become what's called an APT, Assured Periodic Tenancy. So there'll be no fixed terms at all. Every tenancy will be periodic from day one, meaning effectively it's a monthly contract. You don't have to do new paperwork every month. It's a one-time agreement, but effectively it's a monthly contract. And it carries on for life until one party breaks it, the tenant or the landlord. Now, the tenant will be able to give 2 months' notice. The landlord will have to give probably 3 or 4, depending on the reason you want the tenant to leave. Now, you'll still have to do the same things you do now before you sign a tenancy. So you need to give tenants copies of the safety certificates, gas certificate, electric, EPC, and a copy of the How to Rent guide. Although that How to Rent guide will look dramatically different from the 1st of May. You'll still need to issue all that to the tenant before they sign the tenancy agreement. And in the next presentation, we're going to cover what happens to existing tenants on the 1st of May. So if your tenant moves on the 10th of April, what will happen on the 1st of May? So the APT will now just have a start date. There'll be no end date to it at all. Effectively, as I say, it's a lifetime contract that will carry on a monthly basis until one party breaks by giving the appropriate notice. And the maximum rental period in that contract will be 1 month. You cannot prorata for longer. So if a tenant moves in on, say, the 15th and says, can I give you 6 weeks because I want my payment date to be the 1st, you can never accept more than 1 month's payment. Now, I've attached a link here where you can find examples of what the new APT is going to look like. The government have issued some draft tenancies. Moving forward, the tenancy will be a standard document. You will not be able to add additional clauses. Your tenancy will be a standard document prescribed by the government effectively. Now, these ones are drafts. They are subject to change, but it will give you an idea of what the new APT is going to look like moving forward. Now, you'll come under APT rules if you meet certain criteria, and this is going to basically be just about every tenancy within the UK. So if your rent is more than £250 per year outside of London, so £20 per month, or more than £1,000 a year within London, if you charge less than £100,000 per year, if the tenants have exclusive occupations, so it's not a licence, and this would include HMOs generally, because that will still be an APT, but it would be for the room. Or if the landlord doesn't live in the same buildings, if you're renting a room to a lodger, for example, it won't come under the APT rules. But as you'll see, this is going to affect 99.9% of tenancies within the UK from the 1st of May. Now, what I would say is, before we come on to what Infinite are doing about all of this, a lot of the things we've talked about in reality are hardly ever going to affect any of our landlords. We're trying to point out what's changing to you so you understand the new rules. Most of the things we've talked about, you're not going to get caught out, particularly if you're using a good agent who understands the rules. There is a danger if you're self-managing that some of these items might go under the radar. But you must remember, we live in a ChatGPT age where everyone is a lawyer nowadays, and the government are going to be doing lots of publicity campaigns to tenants about these new rules. about the Renters' Rights Act. So tenants are going to be very aware of what their rights are after the 1st of May 2026. So if the tenants are going to be aware, as a landlord, you also need to be aware, and you need to make sure that you're bulletproof as a landlord and that you cover all your bases. So moving on to what Infinite are going to be doing moving forward. Well, first of all, we've been one of the first agents in the country to trial the new Good Lord Guarantor product. So as I mentioned, we use the UK's biggest referencing company, Good Lord, and they are bringing out a new corporate guarantee product, which we've been trialing for the last 4 months now. Effectively, what happens is here, Good Lord will act as a guarantor for the tenant. So the tenant will have the option to pay 1 month's rent as a fee to Good Lord, and Good Lord will then provide a guarantee on the rent for the next 3 years of the tenancy. It will only be for 3 years. The policy cannot be renewed. So after 3 years, the guarantor will drop away. However, you would hope after 3 years, if your tenants paid the rent every month, will have done numerous inspections by then. You'll be comfortable at that point that you've got a good tenant on your hands and you no longer need the guarantor in place. It's not to be confused with rent protection. The tenant is paying for this. It's the tenant's policy, not the landlord's policy, whereas rent protection belongs to the landlord. Good Lord are not there to advise against the landlord. However, they are acting for the tenant. So they will do everything they can to try and mitigate their loss, obviously, and they will try and negotiate things with the tenant. So please don't confuse it with rent protection. It doesn't cover all your legal fees. It's not the same policy. Most importantly, due to the tenant fee ban, we cannot force this on a tenant. So if you're advertising a property with a guarantor, you cannot say to a tenant, you have to have Good Lord Guarantor. If a tenant comes to us with their own guarantor and you're happy with their mum, dad, sister, brother, and they pass referencing, we have to allow them to use that guarantor. We can't say, no, it's mandatory. You use our corporate product and ask them to pay, because there's a fee involved to the tenant. The tenant fee ban means we can't mandate anything where there's a fee involved. Now, obviously, the tenant must pass referencing. The Good Lord Guarantor won't work on tenants with large adverse credit, don't meet affordability, or there's something in the background they're not happy with. They're only going to guarantee tenants where they think there's a realistic chance that tenant's going to pay. But where it can work is for those tenants that I mentioned previously who would normally pay up front. So the way Good Lord works is if a tenant's got 12 months savings in a bank, generally they will pass referencing. They'll use that as affordability, if you like. So if they can't prove their income, but they've got significant savings, they'll accept that as an alternative. So if you've got a tenant moving from abroad, has a significant amount of money in the bank because they've sold a property and can basically show that they can pay the rent for 12 months, then Good Lord Guarantor may work for a tenant like that who might not have a relative in the country who can act as a guarantor, that they might have a working family member, etc. So there are options that this policy would really benefit. We've talked about the payment process before. One of the beauties of using Infinite is Good Lord, our referencing company, have a very clear and transparent payment structure, and it's very, very automated. So the second the tenant and ourselves sign a tenancy agreement, they will get a link to make the payment, and they will be chased literally every half an hour to say, you've not made your payment, you've not made your payment, you've not made your payment, to make sure that payment is made before the move-in date and before we hand over the keys. The tenancy agreements have all been pre-calculated, so you know that every amount on there is going to be correct. The holding deposit won't be a penny more than it should be. The security deposit won't be a penny more than it should be. And the wording of the payment structure will be in sync with the payments we're going to take. So everything will be fully audited, and you will never have an issue with our tenancy agreement should you need to go to court with a tenant. Now, unfortunately, one of the things we are going to have to do is change our finder's fee for some people, not for everybody. This will depend very much on the tenant profile that you'll be attracting. So from the 1st of May, our current finder's fee of $495 plus VAT will remain the same. However, this will now only include 2 reference parties. So for anybody we need to reference over and above the first 2 people, there'll be additional charge of £100 plus VAT. So I'll put some examples at the bottom here. So if you have a single tenant and a single guarantor, it will still be $495 plus VAT. If you have a couple moving in with no guarantor, again it's 2 people, the finder's fee will still stay at $495 plus VAT. But if we need to add more people, so for example, if you've got a couple moving in with 1 guarantor it'll be 595 plus VAT. So that would happen if that guarantor, for example, earns enough money to guarantee the full rent. Then occasionally you will only need one guarantor. But if they can't provide that and they need two guarantors, then obviously be an extra £200 charge, and it'll be going up to 695 plus VAT. So I think that's pretty much covered everything regarding creating an AST. As I mentioned, the next two presentations will cover managing AST. So if you've got questions about what happens once your tenant's moved in, please try and hold them for another couple of weeks until we get the next presentation out to you. However, if you've got questions about anything we've talked about today, you can email the email address on your screen, the info@infinitepropertyltd.com. Please put RRB in the subject, Renters' Rights Bill, and it will be sent straight over to me or Emma or Simon. We can come back to you with the answers to your questions. If it's anything at all, please send it over and we'll come back to you as soon as we can. Other than that, thank you for listening, and we look forward to speaking to you soon.